Good evening, folks. Welcome to another session from the Old Wise Society. Solemn Declaration. Recognised by an act, for me, is the method by which, if you are presenting your standing, then this is the format you would use or consider. And of course, it's important to add an image of you and likeness, because of course, that's what you're declaring. That image and likeness, which is your face, is whatever you're going to write down there on the actual document. Right? So if you're going to use it, just brief yourself with the act itself, why it was formed, what its power is. We've changed it in Australia so that you can't do it. You've got to get a declaration over there, you have to fill in a form. And if any lawyer dares encourage the common law statutory declaration operation, they face up to a $750,000 fine and knocked off the gig. Poverty, on the streets, whacked up on crack. So they're not going for it. So obviously they're all baying it. So you can't use this in Australia. We did investigate that some years ago. Not a chance, matey, unless you fully understood the crack. But of course, this next gig that we're looking at. So there is the instrument that of choice for me. If I am in any way form saying to somebody, "Oi, geezer, just all your assumptions and presumptions are gone. This is who you're dealing with, pal. You may continue if you wish, but I warn thee. Be careful. You don't fall foul of a false claim." So basically, it goes through, you need to define the terms of the situation you find yourself in. So you need to know, what are they operating with that gives them authority? What is their authority? What is it aimed at? And are you that it's aimed at? So that's you defining the terms in relation to this little shindig. Your main point of reference for your common law rights would be the Liberty of the Subject Act. You've got the Bill of Rights within there. You've got a plethora of pieces to pick, whichever is relevant to your particular issue. We go through the actual validity of authority of any liability order that's being thrust around today, because according to its own data, the actual ability for them to have legal power to offer up liability orders ended in 2003. Your common law rights, which is the rights of the individual man or woman. Okay, so when you're defining terms, you would say to yourself, well, am I man? Am I a woman? Or as I present, it's am I man, not a man? Am I man, male? Or if you're a female, female, because that's the way it's depicted in Genesis 1. And does the letter or claim or those trying to blank me, are they using the term man, individual or woman? Because if they're not using the term individual or the term man or the term woman, then what are they aiming it at? And are you it? And of course, as we all know, they're aiming it at the person. Well, of course, you're only a person if you don't understand what the person is. When you start to understand what a person is, you realise pretty quickly that you actually don't want to be the person, but you need to understand that you actually have something attached to you that you can actually use if you learn how to use it correctly. At the present moment, that's not known, and so it's all about their game and how they approach you're coming in, identifying as it. So then you're looking at the common law doctrine of agency. You need to understand the difference of principal agent, what it means in essence, because the principal is the one that gives the orders, the agent is the one that's there to carry out the continuum of the system. That's its job as an agent. Then you've got the Interpretations Act of 1978. It's a follow-on from an earlier one as well. But basically, if there are any words that you don't understand in the claim, then you can always refer back to the Interpretations Act to see if it's in there. You can go through the Black's Law if you wish. But ultimately, that's if you're looking into the vehicle that they're using, which is a statutory act or multiple statutory acts. Again, can be involved in a particular claim. And that's, you've got to see as their vehicle. That's what they're coming to you and operating, yeah, and enforcing and abiding by. So, of course, if you're not what it is it's aimed at, then there's where you're going to present your standing. In, as I've suggested, as I use an instrument called statutory declaration. Now, of course, this isn't advice. I'm always presenting to people what I've done myself when I come up against certain things that I have in the days when I used to go out my way to sort of learn things about it. Not so much these days, of course. So the Interpretations Act is a good thing to go for to solidify what it is they're actually saying to you, its limitations, and thus you can see whether you are outside of its remit, its power, and its authority. And again, you could then cite that. Because once you start to look at these claims in this manner, so you're saying, well, I'm not that, then you've got a cause to actually respond to this claim, haven't you? You've a cause. And that cause is they've approached you on the assumption or presumption that you are something. And that's incorrect, so you need to make that correct, don't you? And you do that by presenting your standing. And so you've got your common law rights is what you're pretty much looking to invoke. And then you've got canons for statutory construction. Again, this is just further explanation of how they construct things, how things are constructed, how they're looking at it. Because once you start to see it in those terms, you can start to see how you can fall into the traps. You can see that they're using specific words because they want to fix it to commerce. Yeah, but this, like I said, it's a compact system, and it's legitimate, and it's actually, it's your right to know this knowledge, because basically, if you're looking at it, once you start looking at it from this side, you can actually see that it's in there for you to find yourself, in order you can steer yourself or walk on the waters of commerce, as it were, without falling in. So canons of statutory construction is interesting to look at, is to understand better how they're forming it, what they're saying to you. Disjunct canon, that's another canon whereby they used for looking at the structure, again, of communications. And this is, you can see how they're forming theirs. And 3, and you can see how you then need to respond. Then of the same kind or class, Agisdum Generis, again, another insight into how they're structuring things. And then monster, one who cannot own property, is a definition found within their system. And of course, the definition of a monster, so before that, is a human. Hence the reason why they're banding about with all these human rights, because they completely control it. Because of course, coming in as a human, you're still coming in as a monster, and classed as one who cannot own property. This is why they want all these immigrants in, you see, pulling out and going, my human rights here, and the European human rights there, and blah, 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 blah. Can you see the game? Yeah? Also, another maxim that they use is, you shall know a word by the company it keeps, meaning the context of the word can also be gleaned by the words in which it finds itself. So the narrative, the context of what it's saying. Because they're always looking for ambiguity. Because if there's ambiguity, then it needs a ruling. When I've presented stuff that we do, we always offer interpretations at the bottom. So if we're using a word that we know can be ambiguous, we will define it as we meaning in that communication. So of course you've cancelled out any other potential meanings, which means you don't necessarily have to get too excited about the canons, but they are interesting in and of themselves and well worth being at least aware of them. And so we avoid that necessity, if you will, by just making sure anything that's ambiguous, we are citing our meaning on that communication in an interpretation, or indeed a definition, whichever way you want to call it out. A game in which, or a tool in which you can rebut commercial claims of all kinds. But in so doing, in this particular instance, we are invoking the common law rights. So of course you're going to have to know them. But you don't need to know corpus mounsum. Magna Carta is the start of it, and it moves on from there. And to do this, there has to be a distinction between you, flesh and blood, and the entity to which all the claims are being made. The distinction comes in the fact that you, as the principal upon which all commercial duties, import of excise, customs and obligations are being misapplied due to the fact you are a man, male or female, and not the person to which the claim is addressed. So that's basically the foundation of the distinction that this system gives you the capacity not only to know, because you can write it down and communicate it, but you can also, it's there all the time, so you'll just run to this for every communication, no matter what and when. And like I say, it's compact, it's a great tool. It really is a great tool. Comprehension of those rights have to be fully understood, as you are going to be presenting them each time you act. So it's got to be written and it's got to be verbal. Consider that the agent bringing the claim requires a vehicle from which the authority the agent is enforcing is taken. So that's your statutory act. So first you need to know what he's using, that he's claiming to have authority to come to your door. Pretend he's got a liability over you. So consider that the agent bringing the claim requires a vehicle. So you need to know what acts he's using. So you're going to be able to breach yourself at least with those acts. Once the act is known, it's essential the act is read to become aware of the remedy within the act itself. So there's always a remedy in these acts, as we've said before. Some people call it a loophole, but it's a remedy. This is why you need a solicitor. The solicitor knows all the remedies, so that you have to go to him, pay him shitloads of money to write letters that you could actually do yourself if you understood that in that act is a remedy. We don't understand it that way, so people just don't believe there's any need for them to read these acts, because of course if they have a problem they're going to go to a solicitor. That's their solicitor's make the gig. In any communication from the system, they will include words that have a commercial term, because it fixes it, you see. And of course if you're responding, you accept it. The frame of reference for commerce directly invokes duty, imports or excise and customs, and also liabilities and legal obligations. Words within quotations, if you find on any paperwork, fixes the words within the quotation marks as a creature of statutes. That's another one to be aware of, which is a term of art. It is therefore a fiction. Yep. So anything that you find on any paperwork in quotation marks, they are cementing it to be a creature of statutes as a term of art. So thus is fixing it into the commercial side of things. And words are an imperfect means of communication, is how they approach it, and as such definitions have to be applied to avoid ambiguity. Now, as I said, you can go through these canons that we'll briefly go through if you want to understand how they're forming communications, so you know how to form yours, or you can work out which words are ambiguous and offer them up as an interpretation. And you pick the interpretation that you mean, because it doesn't matter, you've fixed it then, that's what you mean with that word. There's no need for anybody else to come in and judge it. There's no ambiguity. And so the way that I've operated and suggested you may consider works. It's quick, but there's nothing ever lost, is there, by actually just expanding your knowledge and working out how they're actually coming. So Interpretations Act, as I said, it's 1978, but it is often an early one as well. For the definition of the word person, you may go there if you wish, because then you can use that in your definitions. Yeah. And then there is no ambiguity as to what you mean by the word person. A negative implication canon, and this is relating to the word itself, includes. Okay, so the word includes is expressio unius est exclusio alterius. And it's a Latin term literally meaning the expression of one thing is the exclusion of another. So if they're expressing the word person, another term, then there's expressly excluding the word man. So that's how they're structuring it. So includes is excluding everything else. So then it'd be worth looking at some words you're not sure about, looking how the interpreter's actually defines it, so that you understand how they're using it. This is a common law principle for construing legislation, which holds that a syntactical presumption may be made that an express reference to one matter excludes all other matters. Other common syntactical presumptions are ejus dem generis and generalia specialibus non derogant. Can't you tell my Latin is just amazing? So basically, it's a Latin maxim meaning that the expression of one thing excludes others. It is generally used as a canon of construction of statutes or other legal documents, indicating that the express inclusion of one or more things of a particular type necessarily implies an intention to exclude others of that type. So it's important that you actually really do. You see, this is the thing, isn't it? When you get a letter through the post, the first thing is you're in shock, okay? Don't read it, because you're not reading it. You're just going like, ah. And then a lot of people's initial reaction is, get on the phone. No, don't do that. You put it away. You need to relax, because you're not reading it, okay? You're not reading the words. You're just saying, you, fine, money, give, we're going to kill, jail, that kind of stuff. That's all you're seeing, and it's blah, 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 blah. Put it down. Do your thing. Come back to it when you've calmed down. And read every word. What are they saying to you? Because you're going to use that as your cause for claim. They've done this. You know you're not what it's aimed at. That's your cause for why you have to respond again to them. Thus, if the description of the act is not within the communication, it excludes any other interpretation of the word. Or if the act is not specific to man and you come in as man, the act has no authority over you. Obviously, these are methods where you can just stop them. But again, it has to go further, doesn't it? If you're going to become settler, what you have to do then is you need to understand how you can use the token, which is, of course, what I'm looking at now. Alright, so this is all the steps that you'd want to know in readiness for when you want to start acting as a settler and trustee for the trust itself. You with me? So this is only the first part, as it were, and this is how you knock them away. You know, just off you go. You can't get anything here, kind of thing, till you understand and learn the rest of the game. So that when they do send a claim, say it's fine. Send me the bill and I'll endorse it. So that's, but of course you've got to get somebody in the state to act as trustee. So this is where the ideas of coming in peace, all sins forgiven comes into play. Or the other work method is, I've got you all naughty, collapse the trust, which some people have done. Some most to the disadvantage. I think there are one or two people around that have actually been successful and are quite content. They don't talk about it much, so you don't get to see exactly what it is they've given up. But if they're content, that's all that matters, isn't it, really? Now, your basis for your common law right, if you want, this is outside the Magna Carta, of course, but it's the Liberties of the Subject Act, 1354. And it says that no man, see how the word man, yeah, of what estate or condition that he be, shall be put out of land or tenement, nor taken, nor imprisoned, nor disinherited, nor put to death, without being brought in answer by due process of the law. So that's a common law statute, that. can't be repealed. So the process of law in this case is not statutory law, i.e. commercial law. This is the common law rights of a man. So that's your fundamental right to come in as a man, to which all common law, English common law rights are afforded, which means all American common law rights, Australian, New Zealand, Canadian common law rights. But of course, process of law, if you don't understand this, you would think it means the garbage that's coming at you from every angle. A secondary body of information for your rights, again, if you need to expand them, is the Bill of Rights Act 1688, and specifically on grants and fines before conviction. Yeah, because these liability orders are fines, but you haven't been convicted. No, they have to get you to come in haplessly into contract. Then the vehicle is active, isn't it? And you don't know your ass from your elbow. It's going to play out its game. So in relation to fines, and several grants and promises made of fines and forfeitures before any conviction or judgment against the persons upon whom the same were to be levied, all which utterly directly contrary to the known laws and statutes and freedom of this realm. That's England, okay? Not UK, not Great Britain, England specific, which is also Wales, okay? Now we're just a reminder of the liability order issue that you've got against all these councils everywhere. Remember, when it's real law, everything has to add up. This is why you need a case management file. This is why they need dates. This is why they're obsessive about everything being in order. Because you're putting things together that you're going to carry for a long time. So the liability order. It says the court may make a liability order for one person for one amount. It can also make one liability order for more than one person and more than one amount in the form of a schedule. But the note here from the what we need to know here more than anything, because this is the foundation of this liability order gig. Note the Form A, originally provided to draw up liability orders, was removed from law from the 10th of July 2003 in Wales and from the 1st of October 2003 in England. So the very form that's required in order to draw up a liability order is no longer there and has not been so since 2003. Now these councils have been unlawfully, fraudulently collecting council tax on our ignorance for all this time. That's payable back. Stakeholders, as the Tesco, all these big companies that class as stakeholders are taking corporate power. They're liable. And no form has been substituted in its place. Therefore, the ability to draw up a liability order is no longer there. And the reason probably is because they'd fall foul of the IRS. They should be falling foul of the IRS anyhow. So without any written record of its order or judgment being issued by the court, an order from a magistrate's court may be invalid. And that's on top of the fact that we know these liability orders are not wet signatured. They're not coming on court paperwork. So they're not even magistrates. But even if it is a magistrate's court, the fact that it's a liability order, that's no basis in statutory fact. Because the very means in order to draw one up is gone. Does that make sense? And this is what you want in your car, this kind of stuff on paperwork. I actually have three case law points on right to the highway as opposed to road as well, but I haven't got them actually in the computer. I unwrote them. Maybe I'm going to have to transfer them because they're very interesting. Because one of the last coppers that I actually had were pulled up by, and I said to him, I said, well, I'm on the highway. Yeah, well, no court's ever gone with that. And I thought, really? But yeah, now there's three. I've got three case law ruled on your right to the highway, unfettered, unobstructed. So that's the liability order, which is very important that you grasp because how can it be a liability order if the means to making a liability order is no longer there? in the statutory realm. And as it tells you there, even if you do get a wet signatures from a magistrate, the fact that the form that he would need to order a liability order and thus a warrant is invalid. Now, unless some common law stuff has been going on in there, maybe is why it says may be valid. Invalid. So there may be other ways around it, I don't know. Now, this is just brief on the constitutional law and why it's important that we get it, because it can't be repealed. And this is a case, Thorburn v Sunderland Council, so it's case law. Lord Justice John Laws, in delivering the judgment, acknowledged the coexistence of metric and imperial systems in the 1985 Act, but rejected the idea of implied repeal. He outlined a constitutional framework distinguishing between ordinary and constitutional statutes, where the constitutional statutes, including the European Communities Act 1972, were protected from implied repeal and could only be repealed expressly by Parliament. So what this were about, this were a fight about a shop using the imperial system, and the council wanted them to stop it and use the metric. They said get stuffed. Council got excited, started finding them either and everywhere. So what he showed was that on the weights and measures gig, that it couldn't be repealed by them thinking it were, because they had another act to play with. It says Laws LJ emphasised that the relationship between EU and national law must be judged exclusively by national law. He affirmed the supremacy of EU law in cases of inconsistency with national law, but constitutional statutes such as Magna Carta, the Bill of Rights, Acts of Union, 1707 Reform Act, Human Rights Act 1988, Scotland Act 1998, Government of Wales Act 1988, and the European Communities Act 1972 were not subject to implied repeal. Now, we need to know what that European Communities Act actually says, because if that can't be repealed on this basis, then what does it actually... Is it to do with ECR? No. Is it to do with the single currency? No. Is it to do with PESCO? No. And if that's the case, then they can't do it using European statutes. But that needs to be checked out. Okay, I've only just sort of come to that thought as we went through that there. What is a statute? Okay, well, a statute is the creation of the legislature, which is the Parliament. And it is a term of art. That's what it is. These councils, and even the government, their authority is prescribed, okay? Which means it's limited and designated, okay? So it's specific, but it's also limited. Now, it says the authority the council hold is limited and delegated. It is a prescription which is a right of claim by presumption or assumption. Okay? So the term prescription or prescribed is a right of claim by presumption or assumption. And what do all councils and all these people have? Prescribed authority. So the only right they have as corporate bodies is the right of claim by presumption or assumption. If we go along with it, we've contracted. There it is in black and white for you. It's not a conspiracy theory. That's it. That's, you now know who they are, what powers they have, and what powers they don't have. So they have the right to make the claim, any claim of right on a presumption or assumption. Coppers, council, everybody. That's what they're doing. But their authority is prescribed by a statute, which is limited and designated. Do you get that? Simple terms, and when they're put together in an organised fashion, as this guy did, Rob, I loved it. I thought, this guy, he's really done his research. He knows, and he's formed himself a system. Like the Solemn Declaration is another instrument. It's you can build a system around it. And I like this because that system also is good for this system. Yeah, as your method of presenting your standing. So now this is again very important, right? Fundamental premise upon which you must understand who and what they're coming with. And it says they are following practice. So they're doing what they've been doing for ages without a thought for, is that actually procedure? Yeah, as prescribed? Or are they just acting on their own behalf because nobody's pulling them on it? So they are following practice and not procedure. Right? So what you're doing as cause for why you're doing this is you're pointing out that the procedure is not the practice that they are carrying out. Yeah? So that's your cause of action. That you've pointed out, well, wait a minute, guys, you just made a bit of a mistake here. I understand it's your practice, but it's not procedure. You naughty, naughty little boys and girls. Get to bed. It's that kind of gig, yeah? Authority, being as it is prescribed for these people, is limited and delegated by the government. But yet the political power of the government derives from the people, as does the monarch. Don't know where this head of state gig's working on. It sounds to me like he just needs permission from the Church of Scotland, Church of England. All you've got now is full-blown Presbyterians. And where are they pulling it? Where is it being navigated to? A ship. A big ship called No-Hide Law. Oh, actually, they're called the No-Hide Commandments. One to start to get to become aware of if you're dealing with the councils is the Local Government and Finance Act, especially Section 8, because it's the words used. They use residence, don't they? All this malarkey. But in truth, your home is a dwelling. It's not commercial, it's domestic. They're assuming with all these taxes they're putting on you, the rates, that you are acting in commerce. And unless you are, then you're domestic. Okay, but more important, in case law, it's actually classed as a dwelling. And a dwelling is a hereditament. Again, this is common law stuff. Right? So if your property is not doing commerce, then it's a dwelling, a domestic dwelling. It's not doing any commerce. It's not subject to any authority from any statutory act. So this is secondary again, another fundamental practice not abiding by a procedure. You're bringing that to their attention, yeah, in writing. So dwellings, subsection 3 and 4 shall have effect in subsection 6, blah, 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 blah. I'm not going to go through that, guys, because it's just a load of legal jargon, but you do need to know it. So it's basically saying, if the building authority so determines in relation to all dwellings of that class which are situated in this area, blah, 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 de, blah, de. Right? So again, that's their vehicle, a part of their vehicle. But dwellings is actually a common law term, which means you can be used without fixing it to commerce. Dwelling is an hereditament. Mr. Justice Andrew Baker handed down judgment in Corkish v. Berg, offering welcome clarity on the construction of a dwelling under Section 3 of the Local Government Finance Act 1992, and the proper approach to the splitting of a single dwelling into multiple dwellings. This analysis was supported by, first, the statutory definition of a dwelling under Section 3, which provides that a dwelling is a domestic hereditament, which includes any yard, garden, outhouse or other appurtenance belonging to or enjoyed with the property, and secondly, by the application of the geographic test laid down by the Supreme Court in Woolway v. Mazars. Hereditament is real property. Originally, it was property that would be inherited by the heir on intestacy. So this is your estate, your land right. Corporeal hereditaments are physical real property, such as lands, buildings, trees and minerals. incorporeal herediments or intangible rights such as easements or profits, prenderare attached to land. Your trust system, the entire trust system, is based on holding your right to land in trust. There is your right for reversion, both corporeal and incorporeal rights. There it is. Can you see? Back to what I was saying before, we've gone through that because what you're going to come to terms with is the fact that they've presented something to you you know is false. So you need to present a letter to them. And that would be classed as a letter before action, which is going to be explaining the cause of action that you're taking. So a letter before action explaining the cause of action, which is, we would have normally used the term notice, wouldn't we? Forget it. This is the one, because it's actually one of the vehicles. And in such so doing, you outlay all wrongdoings, whether that be a breach of duty or anything that means you're damaged, and the liabilities that they have that you don't, but they're presuming you do, or indeed the cause of the action that you're going to take. But what he's saying there is that you will give them a letter. Now in that is where you would present this data. And if your solemn declaration is there with the image of, etc., and if you've got that notarized, bingo. Your letter before action should be the one and only incidence that you need to carry out in relation to whatever claim or action is come to you. Now, understanding the common law doctrine of agency, again, is important because it's going to give you a grasp on the mechanic between principal and agent. It's very important. They understand these terms very well. And it says in 6 of common law doctrine of agency, the agent in a common law situation owes a duty of good faith to the principal. Alright, so if you switch this around, alright, you're the principal, they're the agent, they have a common law duty of good faith to you and must not make undue profit from an abuse of the agent's position. So if you're going for reversion, you don't want to come in and collapse the trust. You're saying, okay, no problem, we'll carry on. I want beneficial share. We'll carry on, we're not going to upset you, we'll keep the apple cart going. Yeah, you can do that. But on the condition that the duty of good faith owed by the agent, the trustee, to you, the principal, has to be in sync with them not making too much of a profit. Okay? Which they've been doing for a long time. Damages. They owe you. They have to make it right. Okay? They cannot pursue conflicting interests and has to disclose if a third party benefits. Okay? Which is what I've asked YouTube to supply me with, the information. I want to know who the third party is. So I don't want it at YouTube. YouTube are just doing what they have to do because they're on these vehicles. I want to know who's made this claim, and I want to know that it's real, because if it's not, they're guilty of tort interference. They've interfered in an existing contract. And if their claims are not valid, in accordance with my rights in common law, then YouTube, you're not in any bother, excuse me. Oh, you're not in any bother at all. This third party is. So it's important as a good faith to the principal. It has to be disclosed, third party beneficiaries. If the agent does not do so, this could be said to be a breach of implied duties. Yeah. So you're not saying to him, I'm going to kick your ass. You're going, gentlemen, there's been a bit of a cock up here. Go straight away, you're showing him who you are. You don't want to be kicking off with each other. You want to get to a level playing field. Yeah? And you want that duty of good faith to you, the principal, to be honoured. Specifically in this act here, he's telling you, common law, that it's specifically that they can't make too undue profit from the abuse of this position. It's subtlety. It's checkmate, but you're not kicking their heads in. You're not screwing them half to death going, oh, I'm gonna... And it's private. This is you dealing with the state in the private. You're not telling everybody on YouTube. You're not telling everybody on your social media. That's the basic premise you have to come to and understand if you want to ever start to learn this idea of reversion and getting basically shared interest in the trust. Get rid of the anger. There's no anger needed. This helps you to understand. When you understand something, you're not confused, you're not frustrated, you have a good chance of not getting angry. So again, this is looking into the construction of statutes. You've got Jesdem Generis, which it mentioned up there. I've obviously put everything that I've mentioned in this PDF, and it's worth reading these canons. So its construction principle of the states that where general words or phrases follow a number of specific words or phrases, general words are specifically construed as limited and apply only to the persons or things of the same kind or class as those expressly mentioned. Okay. Again, it's just understanding how they construct the game. Disjunctive canon, again, that's another. It gives you a quick opt-out as well. If you're not doing very well at coming across with this and you just want them to go away. So, signature. It's important. Now, what he brings to the table is, he calls it a commercial code caveat. If you, without having to explain it, or you've explained it, they've not accepted it, and they're just demanding you sign it, you're going to get arrested. The way you keep your rights that you've got, you know, and that straight away when you get home you're going to put together and send to the Chief Constable, the way in order you can get out of the situation and keep that ready for you to go home and write that and send it, is you will sign it off as UD 1-207, and then you must write also without prejudice. Me personally, that's how I'd sign it. I wouldn't put anything else in apart from UD 1-207 without prejudice. That's all I'd put. I wouldn't even put a signature. That'd be the signature. Yeah? That's what I'd do. And it's UD stands for under duress. There's a second one, UD 1-307. I can't remember its variation, but if you look it up, you'll find it. So this is commercial codes, by the way. Okay, that's what you want to be looking for. Now, what he mentioned as well, that he sends the V5X and he exercises the caveat right, UD 1-207, without prejudice. And there I offer a bit of an explanation on without prejudice, full disclosure, equal consideration, lawful terms, conditions, etc. for your consideration. Now, when you sign off with that method, it's not a signature of acceptance, it is a signature of convenience. And that is an excellent way to describe what you've done if they questioned about it, and you could add it into your paperwork as well. Did you get that, geek? Till the next time.